I think we're good.
All right. Good morning and welcome to our Win Without Law School Live, which you can see on TikTok and on our Decode Your Divorce website, Facebook group. Welcome. We've got 980 people in the Facebook group, and apparently once it hits 1,000, it's something magical happens. So if you if you want to invite your friends, that would be fabulous. Julie, how are you doing this morning?
I'm doing great. For those of you I haven't met before, I'm Arizona lawyer Julie LaBenz. I'm based out of Sedona. I connected with Billie last year, and we've just had a lot of fun creating new content, exploring different areas of family law, specifically looking at how to help people representing themselves. And also paraprofessionals, people who want to be lawyers but don't want to go to law school and pass the bar and all of that. There's a new option in Arizona where you can actually do nearly everything a lawyer can do, but you don't have to go to law school and pass the bar. And it's called a legal paraprofessional. So we have been creating some resources, and we held a workshop, and we've done all sorts of fun stuff. And now we're doing these weekly lives, and we're planning to keep doing these. So check us out Thursdays at 11. If you have any suggested topics, feel free to share those. But we're going to explore all sorts of different family law topics, specifically around Arizona law. And, keep in mind that what we talk about, we can't give legal advice. We don't know, enough information, and don't have a client agreement with you to actually give you legal advice. But we can't give you legal information based on our experience and knowledge of the law. And we don't become your attorney through doing this, which for some reason the state bar wants us to tell you that, which I think is kind of silly because you probably know that, but they want us to tell you that. And this is based on Arizona law, but we're open to your questions. So feel free to throw some questions in the chat. And Billie, how are you doing? I know you had a fun New Year's, and you're excited for 2023.
I am. I'm so excited for 2023. I'll tell you, 2022 was a little chaotic. Like if I have to look back on it, it was a little chaotic. And I'm looking forward to it not being chaotic. I'm really glad that you mentioned the legal paraprofessional. So that was sort of the real initiative push that Julie and I got to create content to help people better represent themselves in family court, was because we are both huge fans of the LP program, which allows paralegals to become licensed to practice law. Arizona is the first state in the entire country to allow this. It's super progressive and we love it. Not all lawyers love it. We love it. And so we wanted to come up with a way to really help support those LPs. In doing that, it became painfully obvious that people who are representing themselves need this information just as much as anybody else. And we were already in that community. We already had our Facebook group. We already had all of our TikTok viewers who are constantly having this conversation with me about your questions, my answers. So we're so excited to kind of take that educational component and training component to the next level, which is Win Without Law School. Live classes start on the 9th. We've also been checking out like other resources, and this is the best resource in the country available for self-represented litigants, without a doubt, because you're not just getting passive classes, you're getting actual teaching, live teaching. So it's pretty exciting.
It is really exciting. And, Win Without Law School is really unique because really so many people just bury their heads in the sand. It's like the ostrich effect, like, oh my gosh, this is so overwhelming. And there's nothing really out there to help me, and I can't afford a lawyer, so I just don't know. But that's so risky, especially in family law when like your most important relationships are involved.
Right.
So this is an opportunity to have, someone to hold hands with and walk through this process so that you're not alone and that you have information that you wouldn't have otherwise, which can help you ideally put yourself in a powerful negotiation position and get your case resolved. We're going to show you how to go to court too. If, for example, you're up against somebody who's just super litigious or unreasonable, and you're just getting pushed into the courtroom, even though you don't really want to go there, we can help you as well. But the majority of cases get resolved, especially if you have knowledge. You know, a lot of people end up in the courtroom in these trials because they just don't understand the process or what to do or what to talk about. But we're going to give you those tools so that you can ideally completely avoid court and start building some really strong communication and negotiation skills with your co-parent. Or alternatively, if you need to go to court, go in with confidence, go in with some good exhibits, go in with a nice trial outline. You know, that can make such a difference. And I can't wait to see some of these judges' reactions to people who are prepared. I mean, it's going to be really awesome.
Yeah, it's going to be really, really awesome. One question we've got about Win Without Law School is, will there be sample documents to use as reference guides on how to actually format it? For example, what does a pretrial statement even look like? What should the format be? What language should I be using?
Definitely. You know, that's something that we talked about in our trial skills course. We did talk about the pretrial statement, how important it is, and talked about there's a rule that controls the pretrial statement at 76.1, if memory serves. And it gives you a list of everything, I think, you know, A to Z, it's almost that many subparts of all the details that the court wants in there. And so what you can do is create your pleading and just list all of those subparts and then fill in the information. And what you fill in is really important, because the judge is going to use that as their kind of outline and guide to your case.
That's the last question we've got for now on Win Without Law School. Today's topic is going to be one that a whole lot of you really want to know about, and that is court-appointed advisors, parenting conferences, comprehensive family assessments and evaluations, all these third-party experts that are often appointed by the court in highly contested custody cases. Now, Julie was telling me that that is a little less prevalent in Yavapai County.
Well, not just Yavapai County, but all of the rural areas, all of the rural counties, because the resources just aren't there. For 6 years or so, I practiced out in La Paz County and Mojave County out in Western Arizona. And Mojave County had a bit more resources, but look how no resources. So you hear about parenting coordinators and mediators. And we didn't have any of that. You know, as an attorney, you had to take over a lot of those roles. In Yavapai County, there's some additional resources, but a lot of the times those are reserved for people with money, because you're paying several $1,000s for reports, and now, you know, and not everybody can afford that. So it's not something that transpires in every single case. Tell me about what it's like in Maricopa County, Pima County, and the bigger areas in Arizona.
Yeah, well, what I see in my office and what we're seeing on our Facebook group is a whole lot of people have questions about CAAs. CAAs can be appointed by the courts with or without you asking.
Explain CAA, because you're using the acronym.
Yeah. So a CAA is a court appointed advisor. So, and somebody on TikTok just asked, well, what about a GAL? We don't really have guardian ad litems in Maricopa County. They probably are the same thing, maybe, as a CAL or as a GAL or a best interest attorney. I think a GAL, a guardian ad litem, is a attorney, right?
Right, like attorney for the child.
And so that would be akin in Maricopa County to what is sometimes appointed as a best interest attorney. A court-appointed advisor does not have to be an attorney. So they are, which is really problematic to me. I mean, I have to tell you, I don't love CAAs. I don't love CAAs. But what they do is they are appointed to investigate, and there's some boilerplate rules in their appointment. They're supposed to look at, you know, DCS records, everybody who lives in the home. Like, it's a random comprehensive, like, safety check, like, check your boxes, ask this in every single family, in every single case, regardless of what your actual issues are in your case, which I don't like. And then they make recommendations based on the statutes. which means, I mean, they're arguably practicing law, and judges, many judges give their investigation a whole lot of weight. And why? It's probably because the court appointed advisor has spent a whole lot more time with the parties and the evidence than the judge. Now, is that appropriate? I just don't think so. And I have to tell you, in my experience, 7 out of 10 times, maybe 8 out of 10 times, we're not happy with the CAA report. It either misses things, it's inaccurate, and there are ways to address that, but most people don't know about it. So most people don't know how to properly address one of these reports when they come back wrong or inaccurate or incomplete. And sometimes even CAA reports will get the information wrong. They'll be referring to people that aren't even in the case. So I don't know if you have any experience with that, Julie.
Well, one thing I've found highly problematic is when the CAA decides they like one parent and don't like the other.
Right.
And it's usually when the parent they like is super manipulative. And so this manipulative, they're manipulating the CAA, they're putting on this fake impression and bad mouthing the other side and already planting seeds, turning the CAA against the other side before they've even met them. And sometimes they can be very effective, but by the time they're interviewing the other side, they already don't like them. And they're looking to confirm the things the other side has said. So that's a bad experience that I've had. And some of that stuff can be really hard to undo.
It really, really can.
Judges can really rely on those reports, and it's tough to combat that evidence.
Absolutely. Absolutely. And it's especially difficult when there's domestic violence, because the dynamic that often occurs in relationships where domestic violence is present is the abuser is highly manipulative, skilled, controlled, put together. And I had a case where a comprehensive family assessment was ordered because my client was allowed to relocate, and dad didn't like it. And that was the only reason that the comprehensive family assessment was ordered. Now, I had a problem with that for several reasons. Number one, dad wanted it. Dad should have paid for it. It shouldn't have been a good CFE. It should have been, if you want that, you go hire your own expert. But that's not what the court did, because some judges will just say, yes, yeah, let's get more information. So that just depends on your judge. But this CFE provider was a much older male, and he didn't like my client, and he loved the abusive, narcissistic, charming husband. And the other thing that we found out as we dug into this, because this client of mine had resources, she had somebody that was really supporting her and she wanted to dive in. One of the things we found was that he provided her and tested her on an old MMPI. This was a 1980s, an MMPI-2. So that's a psychological evaluation. Now that we know as lawyers is grounds for disqualification, a Daubert challenge. Now, do you want to talk for a minute about what that means? Like, what does it mean to challenge an expert in a Daubert challenge?
Well, in order to be deemed an expert, you have to have sufficient knowledge or experience. You need to have something that makes you special on this particular issue. And if it turns out that you're using outdated, data or research or facts, then is your opinion really worth anything? Right. And the court is only going to want to hear an expert opinion that has some validity to it, not something that really is worthless. So that can be tough. Like you said, it took resources to get to the bottom of that investigation and then be able to present that to the court. That can be challenging.
Experts are not allowed to present old, outdated information or super novel theories. A Daubert challenge, it allows you to go to court and say, listen, this person is not following the standard of practice that is accepted within this industry. Now, this is the type of thing that most people who are representing themselves don't know, but it's very powerful. And if you can go to family court and say, this person is using outdated testimony. Oh my gosh, my child's trying to break in. Hold on.
I'll take over for a few minutes. You know, in addition to the report itself, something that's really important is how are you preparing for the interview with the custody evaluator or the CAA, whoever it is that's been appointed. You know, what steps are you going to take to prepare for that interview? And how do you want to show up during that interview? Because if, for example, you have a dirty house and you don't tidy it up before they come, they're likely going to criticize you about that in the report, and it's going to get harped upon. I've had that happen in a couple of cases where my client's like, who cares that I had some stuff in the front yard, like whatever. And yeah, my house was under construction, and yeah, things were, but the CAA went nuts on that stuff.
Wow.
It was like, this is not a place for, you know, a young child, and da da da. And then at the trial, it was made into a really big deal. And so, you know, are you going to take the time to make sure your house is presentable and safe? Are you going to look presentable? And then I think it can also be helpful to do like a mock Q&A with somebody you trust, because answering some questions, you may think, oh, piece of cake, but it isn't, your first answer isn't always that great. And sometimes you'll want to see, oh, okay, you know, I should work through this particular question a little bit more. And I know that can take some advanced knowledge to determine, but I think just when you go through that exercise, you can, and your other side can give you feedback, like, how are you coming off? Are you coming off defensive and rude, or are you coming off as transparent and loving?
Right. And the other hard part about CAAs is when you are going to meet with them, well, we've taught you to be very narrow and focused when you're preparing your arguments for a judge. We've taught you how to eliminate things that are irrelevant, stay focused on what matters, tell the judge what they need to hear. All that's off with the CAA. They can ask you about absolutely everything. And then you're in this weird position where you have to decide, am I going to stick to my points of the things that matter? Or how am I going to handle, how do I make sure that this person is on the same page? They're writing about what I think is important. You have to answer their questions. You know, what if they get hung up on the fact that your ex said that you drink a lot of alcohol or something, and alcohol is not even an issue in your case. It can be very, very challenging. I think you definitely want to research your CAA. You want to know as much as possible about this person. The other thing I want to mention is they don't always come to your house. Sometimes they give you the option where you can go to their office or have them come to your house. I think go to their office. Why? You're eliminating a discussion about your house or whatever judgments they make. Maybe you live in too nice of a house and they don't like you. Maybe you live in too messy of a house. Maybe they don't like your neighborhood. Maybe your neighborhood reminds them of their mom, like just if you can eliminate that and just go sit in their office, that is, in my opinion, probably a better idea.
Yeah, definitely. I would really be paying attention to the questions that are being asked while you're in that interview. You know, what are they getting at? Where are we going with this? Also, I wouldn't go on and on and on with my responses. That's usually when you start to get into some danger zone, when you just like talking and not even realizing what you're talking about. Answer the question and move on. I wouldn't get too defensive when hot subjects are brought up. You certainly can show some emotion, that's okay. But I wouldn't be like, this is off limits and, like the anger part. It's not that your position isn't valid. I mean, having somebody come in and critique your life and your family is very uncomfortable, and it does evoke natural feelings of defensiveness. However, that's going to be used against you. So it's this strange thing where you're trying to be authentic, but authentic in a way that's going to please this person that you've never met.
Yeah, I'm generally speaking, not a huge fan. There's a lot of other things that we could talk about. We could talk about therapeutic intervention. We could talk about this new program called COBE, which is court ordered behavioral intervention for cases where there's alienation. Like there's so much content on these custody type experts. But we also already have 8 questions waiting for us to be answered. And I know that many of you are here to get your questions answered. So we'll go ahead and dive into the questions. This one is from our live stream to YouTube. And the question is, I'm curious what you feel is the most cost-effective approach to working towards a divorce settlement when there's a no contact order in place and neither party can afford a lawyer.
Okay.
Great question.
Yeah, that is a great question. So there's a standard part on the protective orders. So this is the piece of paper the judge signs. And there's a line in there that says no contact except for, something about attorneys, legal processes, court appearances, things like that. So there's an exception for, negotiating, communicating about your pending case. So if you've got a divorce going, you can communicate. Now, keep in mind, a settlement letter is a great way to communicate. Right. And if you need to cite to that part of the order to show you're not in violation, if you think the other side's going to make that accusation, feel free to do so. Another option is to ask for mediation through the court. In Yavapai County, mediations about legal decision making and parenting time are free. A mediation that covers additional issues like property division, spousal maintenance, child support. It's a $400 flat rate, which you can split that with the other side. And it's really reasonable from my point of view if that could get your case resolved. And at least in Yavapai County, the mediators are really well trained. I find they do a good job. It doesn't always result in agreement, but I find them to be fair and very effective. So I think that's a good option. Also, if you have an open divorce case, you can ask the court to set a judicial settlement conference where you can meet with the judge. I don't know how easy it is to get that type of hearing in Maricopa County, but in Yavapai County, it's very common. The judges, some of them will refer it to a different judge, but most of them, if the parties agree, will handle the judicial settlement conference. And that can be one of the most effective ways to get a resolution in place, because if the other side's being unreasonable about a certain issue, there's no better way to convince them they're wrong than the judge, him or herself, telling them, no, I'm not buying it. That can change their position so quickly. So mediation's great, in particular if a judicial settlement conference isn't easily had in your county, but also a judicial settlement.
That's a great idea. It's not used very often in Maricopa County. It's used a lot in Pinal County, and it's called open negotiations. I'm not sure why it's not called a judicial settlement conference in Maricopa and Pinal County, but what I will find is in Pinal County, they will set open negotiations. Lawyers are not allowed to go. It's just the parties and the judge. And yeah. And in Maricopa County, you are allowed to file a request for an open negotiation with a judge. That's just such a good idea. But so just going back to this, if you have the no contact order against you, you are prohibited from making contact, you need to be very careful. You need to read your order very, very carefully and ensure that your contact is not violating it, because violation of an order of protection that is in place against you is a crime. So the order of protection is a civil order, but violating that is a criminal issue. And if you get that, it's going to make it very, very difficult for you to settle your case. So definitely be careful. If you're the party, if the other party has the no contact order, you're not violating it by sending a settlement letter. You can't violate their no contact order. So just something to keep in mind. Next question. There's no custody agreement, no parenting plan. Child support is through DCSS only. The opposing party does not ask for or see our child on weekends. Are there grounds for abandonment, even though he is garnished for child support?
I mean, why? What's your remedy? Are you just wanting to, and what do you think, Billie?
Well, I think the term abandonment, isn't particularly helpful, because there's no place for the word abandonment, except the only time that is legally relevant is if you want a termination. And if you want a termination of his parental rights, because let's say that you're remarried and there's a stepdad in the picture who is this child's dad, and the biological father literally has no contact ever, then it does matter. And simply paying child support does not get you over those grounds for abandonment for termination purposes.
But if you terminate, doesn't the child support order go away?
Not necessarily. So the juvenile court would have to determine that ending child support was also in this child's best interest. So let's say there was a step parent adoption, child support would probably end. But there are cases where there's terminations and child support continues.
Yeah, so I think really, what's your goal? What would you be trying to accomplish through an abandonment? It's interesting. It's like there's no happy medium sometimes. It's like either a parent's complaining because the other side's too involved and they want them to be less involved and it's annoying them, or they're upset that the other parent isn't involved enough. And it's like, maybe them not being involved is actually, it's difficult for the child, don't get me wrong, but as far as co-parenting goes, I can tell you a lot of parents be like, man, I wish I didn't have a co-parent that was involved and I could just do what I wanted and I was still getting child support, and wow, that'd be great. So I'd be curious to know what else is going on there, and if it's just an emotional upset, which is totally understandable,
right?
Or if there's something else going on to where legal action would be merited.
Right. Exactly. Because the only thing that the only reason this might be relevant to me as a lawyer would be, oh, are you looking for termination? If not, there's nothing the family court can do to force this parent to get involved.
You could potentially modify parenting time and child support. Like if, for example, that child support order that's in place is theorizing that he has 50-50 custody.
Oh yeah.
And then he's not exercising that time, then you could modify child support based on that, and that could make a big difference in the child support calculation.
Right.
And then you could get a parenting plan established that shows, he only gets 1 weekend a month, and then see if he does that. So you could use this as evidence as a basis for a parenting plan or a child support modification. Potentially.
And sometimes it is not until there is a parenting plan in place that regular parenting time happens. Sometimes what happens between a couple is one person, mom usually, is the de facto parent, and dad, without the structure of a parenting plan, doesn't come around often or consistently. And then maybe when he does, it's not convenient. And so he's told no, and then he just gives up. And sometimes the structure of this is your time, you're responsible for it, is a great thing for the child, mom and dad.
Sure.
What can I do if the father of my child makes cash and I cannot afford a PI to prove employment?
Oh, you've got so many options. So one thing is to consider the Arizona Child Support Guidelines. Within there is a section on income attributions. So this goes back to a case called the Little case. It was a divorce initially, Mr. and Mrs. Little, and Mr. Little was in the military, and he was getting a really good salary. I guess he was a pretty high-ranking official in the military. And then through his divorce, he got interested in the law. And post-divorce, he decided to leave the military and go to law school to become a lawyer. And when he started going to law school, he petitioned the court for a modification of his child support and said, hey, I'm not making what I was in the military, so you should reduce my child support while I'm in law school. And the court said, no, you voluntarily reduced your income, so we're going to still attribute to you your military income because that's what you're capable of earning. And so if you have a situation where somebody's receiving cash and it's hard to account for, you can ask the court to attribute income to them based on what would be a reasonable amount of cash they should be earning. Alternatively, you could say, look, based on their experience and job field, this is the normal pay rate, incorporating cash bonuses or whatever. And so we want to attribute this annual income to this person. Those are a few ideas, but just because you can't prove the exact amount Doesn't mean you don't have options, but the thing you'll want to do is take a position. You can't just come into court and be like, well, he makes cash under the table. That's
Right.
too vague of evidence. You'll need to say, I estimate he works 5 days a week. I estimate with each shift, he's getting $100 cash. That's $500 a week times 4.33 weeks. That comes to this amount. I would have a proposed calculation that now the other side has to rebut.
Right.
And they may or may not be able to do that.
That is so smart because, yeah, they have to rebut it. So if you come in and you take a position and you tell them how you got to your calculation, they have to show what the actual answer is, right? Another way you can prove how much income somebody has is by working backwards and proving how much they're spending. So you can take a look at their AFI. What do they say their expenses are in their AFI? This works really well. So many times people will say they make, $2,000 a month and their AFI will show that they've got $6,000 of expenses. And then if they're paying those expenses each month, you can, times that by 1.3 or 1.2 and ask the court to attribute that for income because that's what they're spending.
Yeah, so you have a lot of options here.
So many.
It feels like you're powerless, like, oh, how do I prove this? And they're pulling a fast one. But you have to also realize the judge is so savvy to this type of stuff and is looking to find a dollar amount to attribute in most situations because they don't want somebody to get away with, pulling a fast one on the system through using cash.
Next question. What is the best way for me to get a new GAL or best interest attorney? Ours is obviously biased and lied in court.
I don't know. I don't know if you can be successful at that. If you can prove the lie, you may have some avenues there. I'm really curious what that lie is because sometimes things that some people perceive as lies, they tell me and I'm like, there's kind of two sides to the story and they're just taking a different side. It's not necessarily a lie. So I want more information. If this was a clear-cut lie, it should be addressed. But if it's two different points of view, then you don't really have a strong case to take forward.
Yeah, I find that these are difficult situations. So a best interest attorney is usually appointed on behalf of the child, or the GAL is supposed to be on behalf of the child. Now, I don't know if that means they have an obligation to listen to the child. And many times there might be children who are older, 12, 13, 14, 15, 16. And those children may have a very clear position. And I see the GALs or the best interest attorneys take positions that are not in line with what their client, the child, wants. Do you have any, I don't know, is that okay?
I think it kind of goes back to this concept of should the child make the decisions?
Right.
And it is this big gray area. A kid could say, oh, I want to be at mom's house all the time because she has the best video games and the great junk food and, whatever, lights the kid up. And should we follow that preference of the child that's, based on things that really aren't the best for the child? So it's not easy. And let's be frank, a lot of these court-appointed attorneys are paid by the court. It's kind of like a public defender. You get a certain hourly rate, and a lot of them take a lot of these cases because the hourly rate is usually lower than a private lawyer. So they're taking a lot of the cases, and sometimes they don't put in the effort. I mean, it's just a reality. So did somebody not do that great of a job and just kind of flub things because they were being lazy? I mean, it's possible. But yeah, this is something it would be really interesting to know more facts about this one because it's a tough situation. And if it is a really provable lie, that would be something that would be important, particular to the judge. The judge doesn't like any lying.
No.
And that could honestly be a bar complaint too.
Could be a bar complaint. You could do a motion to strike. You could do a motion for a new GAL. We've done that in our office when there was a CAA appointed who didn't do anything for 9 months. They missed their deadline and we asked for a new one, or we asked to have them removed. And And I don't think that the court did remove that CAA, but it certainly undermined their credibility. So that was okay. The next question we've got here is, any tips for litigation with a narcissist?
Yeah. Billie, I'm going to let you start because I know you've written a book that talked about, narcissism and different mental health issues in the divorce context. So what are your thoughts?
So I have a book on Decode Your Divorce 2 is the second book in the series, and it's about litigating against people who have personality disorders or mental health disorders or addiction, because those are the hardest cases. So what you're saying, how do you litigate with a narcissist? It's really hard. I've done it for years and years and years. It's very difficult to get settlements. In my opinion, one of the best ways to do it, one of the ways that I've had the most success, is bringing everybody into my office. Oh, hold on. We've got a vacuum going. Can you hear me okay?
Yeah.
Okay, great. Bringing everybody into my office, because the narcissist wants to seem like a good person. They want to seem like a good guy. So if you can come up with an agreement that makes them feel like they've gotten what they wanted, that is the only way to get a settlement. And if you add paranoia to narcissism, they won't agree to anything, and they won't. And the only thing that, in my opinion, those cases just take forever. And that is a good time for you to become an expert. Go to Win Without Law School. Understand how to litigate yourself, because they often take years and years and years. And even if we get a win in 1 year, that narcissist might come back in a year and file again. What do you think?
Yeah, I mean, it would be easier to talk about this if I knew the dynamic, because not all narcissists are exactly the same.
Right,
Everybody
there's a
has
spectrum.
a different case, facts and situation and stuff. So it's a tough question to answer in that regard. But and because of that, I'm going to answer it in a bit of a different way, which is that I would encourage you to disconnect from the narcissist as much as you can, because you're already like PTSD, you're already in this fragile place with that person, and you need a lot of healing. And that healing, a lot of it is getting you to an empowered place where you actually see things more rationally, because the narcissist is so good at co-opting your life and your thought processes and all of that, and then controlling you through that. So breaking those patterns can be huge. And I think that's number one, because you have to realize you can't change the narcissist. So what can you do to disconnect from that person and start shifting and really reaching a level of acceptance, so that, okay, I understand, yeah, we're going to be in court. This is it. And I'm going to go to Win Without Law School, and I'm going to empower myself, and I'm going to do the best I can. But I'm going to have a good relationship with my kid, and thank God I'm free of this person.
Right.
I think that that's a really big thing that needs to be focused on. You're going through this thing for a reason, and it's to get your freedom. But are you really getting your freedom if you're still totally emotionally entangled with this person and constantly getting upset by them?
I'm so happy that you took that approach to this question. Any tips for litigating with a narcissist? You affirmed that if you're getting out of a relationship with a narcissist, you have experienced trauma. You have been controlled. You will be triggered. You are looking for freedom. And so the tip, Julie's tip, which I think is just so good, is focus on healing and taking care of yourself, so that what they do matters less. And that might be the tip of the litigation, is how do I come up with ways to get through litigation and beyond, where we have as little to do with one another as possible? How do I come up with the simplest way out that gives me freedom?
Yeah, unfortunately, you created this situation. I mean, it's easy to blame the other side and talk about how horrible they are, and I'm sure that they are in many regards, but you chose to create a relationship with this person. You weren't a slave. You maybe had children with them, again, another choice. I understand there can be financial issues, that there can be all sorts of reasons for why you stayed, and I'm not minimizing those, but at the end of the day, you stayed. And so I think that something that can be really helpful is just coming to terms with that decision and realizing how much growth you can actually experience if you're open to it. This person may always be a barnacle on your side, but you could create a whole new life outside of that actually is something that's going to serve you so much better. And then you always have that lesson of, wow, this is the type of person I need to avoid. But yeah, I think Win Without Law School is a great resource for anybody dealing with a narcissist in litigation.
Stuck in litigation for a long
Unless you have, a bottomless bank account for legal fees, Win Without Law School is a great option.
Right. We owe back taxes. How do you think a judge will split that up? We have a lot of equity in our homes.
Usually, 50-50 is the starting point for division of all community assets and debts in a divorce. And if one side wants a division other than 50-50, they need to justify it. They'll need to show what are the special circumstances for why it shouldn't be 50-50. So usually with IRS debt, it just gets divided. You're not ordered to pay it off at the time of the divorce. It's just divided up. And if you have other debts and assets, sometimes there can be a consideration of, do I want to put this debt in my column or the other side's column, with an equalizer so it all balances out, so that one person is making the payment and it's clear. And we're not, oh, did you make the IRS payment this month? And, if you're the responsible payer and the other isn't, and you want to not have IRS problems, you might want to take the lead on paying that and have it offset by some other debt or asset or something else in your divorce.
Yeah, and what I hear here, we have lots of equity in our homes. If you want your back taxes taken care of by the equity in your homes, just ask. It's a very reasonable ask. It's very reasonable for you to ask the judge for your position, and the judge is looking for your position. So if you're going into court, you're saying, here are assets, here are debts, here's what I want you to do. And that's the part that maybe is missing from this question. If you want one of the homes sold, the tax debt paid, any remaining equity split, that's a very reasonable position. And I would say just ask for what you want.
Also, if you're requesting to refinance to take equity out through that way, I would get it all teed up. I consult with a loan officer. I'd get a letter from them explaining you qualify. Obviously, that should also be part of a general resolution of the real estate. Are you becoming the sole owner and buying the other side out and taking out additional equity to pay off the debt? I mean, you have equity in your home, but how are you proposing to get it out? Is it through a sale? Is it through a refi? It's not just cash readily available, unless you take some other steps.
Mm-hmm. Yeah, it's a great point. And refining right now is hard because interest rates that most people have on their homes is better than what your current interest rates are. And that's a really tough thing. The other thing is many people have payments right now on their houses that are lower than they would be if they refied or if they sold. So you make an excellent point. It is difficult to get the equity out. The other thing you could consider is you could say, I'll take the IRS debt and I want to keep the home. You keep the home perhaps at the lower rate if the bank will allow you to assume the mortgage, and sometimes they will. Plus you take responsibility for the debt. Now you've canceled out the required payoff and protected some of that home equity.
And I definitely recommend a consultation with an attorney over any real estate stuff, because that is a huge pitfall. So many people don't do proper real estate stuff if they're representing themselves. And it's a major problem. You can cloud the title. You can have co-ownership issues post-divorce that you don't want to deal with. Just so many things. And one other thing too that an attorney can be really helpful with is a lot of people want to create these really complicated extended co-ownership agreements.
Mhm.
Like, oh, well, I don't want to sell now. It's not, let's co-own for 5 years and you'll do this and I'll do that. And, you know, maybe that works and maybe it's a horrible idea. And so, you know, that's something that an attorney can really help you with. Sometimes it works and other times it's just extending this entanglement with this person you don't want to have connection with anymore. And then there's a lot of money on the line and sometimes a mortgage loan and, you know, or they'll assign the property to one person, but they don't address the mortgage loan.
Right.
And so then you're post-divorce and one person owns the house, but you still are co-obligated on the mortgage and you can't get a new mortgage because you've got this other debt on your credit. And it's just a real headache and nightmare. And you can't amend, you can't change a divorce decree as far as property division goes. There's very narrow exceptions.
Say that again for the people in the back. That's a good one.
There's like extremely narrow exceptions, but in the most part, you cannot change the property division orders within your decree. So if there's some mess up with the real estate, unless the other side's willing to work with you on it to correct it, you may have absolutely zero relief through the court or an extremely difficult case getting relief.
Yes, Julie is 1,000% right. This is non-modifiable. You can set it aside for very few reasons and then you're starting over. Nobody wants to do that. So whatever decisions you make, you're stuck with it. You're stuck with it. And the court can't come in and modify it in order to make it make sense. So I'm just really glad that you mentioned that. Okay, we have a ton more questions, not a ton more time. But here's a good one. Will the judge sign off on a no child support agreement between the parties, which is exchanged for dad giving sole custody to mom?
Yes, if you put it in the correct terms. The terms that were in your question, no, I don't think the judge would sign off on that. But maybe you run a child support calculation and you find that it shows 0. Maybe you run a child support calculation and it shows a certain amount, and then you can do what's called a deviation. And there's specific language you need to include, and you both have to sign off on it and stuff, but you can deviate down to 0 if you could show that's in your child's best interest. So yes, you can do that, but you have to follow the proper steps to get it through. And just saying no child support in exchange for, what was it, sole decision making, I think, that likely will not fly because that doesn't meet the requirements of a deviation or anything else the judge is going to be looking for.
Yep, absolutely. Let us know if you have further questions on that. I've been divorced since 2018, and the one thing that keeps coming up is the house that I shared with my ex-husband.
Oh, how interesting.
We're supposed to split the costs if sold 50-50. Can I request the paperwork showing that he sold it? My ex-husband becomes angry if I bring it up. He said that he sold it and he received nothing for it, but he also makes comments of owning more than one house. I have people texting my number asking about the house, and my ex-husband tells me it's spam.
So in every county, there's a recorder's office, the county recorder, and the county recorder keeps a database of all of the recorded real estate records. So for every parcel of real estate, there's what's called a title history. And within the title history, it's going to show each purchase, sale, purchase, sale, purchase, sale, loans, all that stuff in a chronological order. So I would say stop asking him for the information and go to the title records and find out yourself, was this property sold? Sometimes the title records can be a bit difficult to use if you're not familiar with them. So another avenue is through the assessor's office, which is the property tax office. So you can look up your ex-husband's name and the property tax records and see what addresses come up. And if the property in question, if it shows he's getting property taxes for that property, then presumably he still owns it. Whereas if that's not showing up in the list of properties he's getting tax notices for, then he's likely sold it. And then that also through the assessor's records, there's often links you can click to that will take you to the deeds and the recorded records. Again, this would be a great thing to go to an attorney with and get a consultation, because it sounds like there's likely a lot of money at issue here. You've been waiting since 2018 to get your money. And this could be a powerful enforcement case if he's going to keep jerking you around. One other point, with each sale of real estate, there's a document called affidavit of property value, and it shows what the property sold for and the date, a lot of different information. But if he's saying, oh, I didn't get it, you can actually get the sales price and all of that. Of course, you may not know what the balance of the mortgage was, but maybe you knew what it was in 2018 and can do some rough calculations and figure out what the rough net sale proceed was. If you can see what title company the transaction went through, you can potentially get the settlement statement from that transaction, which will give you $1,000. I love real estate.
Yes. So this information is readily available to you. The other thing is look at your divorce decree. When was it supposed to be sold? Did it say when it was supposed to be sold? There's a statutory interest rate that could be in place where you could be getting interest on your money, depending on what your actual divorce decree says. The other thing is Zillow usually tells you when a house was sold and for what. So there's so many ways for you to go get this information. And a follow-up question was, do you need to check the county to find, do you check the county to find hidden real estate in your client or their spouse's name?
I always look at recorded records in general as part of preparing my initial disclosure statement, because I like to get an idea of all the real estate stuff going on. Do I ever find hidden real estate? I can't think of a case where I ever went and did my real estate record search and found this unknown property in a spouse's name, but certainly that would be one way to do it, but I've never encountered that.
Let's see, we've got 7 minutes left. Let me look at these questions.
So if anybody wants to join our email list, go to winwithoutlawschool.com. Feel free to sign up. We also have a special running right now. You can join Win Without Law School for 1 full year for $297. That special runs through the end of this month. So please, if you're interested, give us a try. $300 is, generally what you're going to pay for 1 hour with a lawyer. And this is going to be 1 year of resources, which maybe you're like, oh, a year, I don't need that much, but cases generally take around that long. So the year is actually a really good set of time. And if you use less time, well, you only pay $300. So fantastic. If you got your whole case resolved faster than a year and you paid $300 to get there, I mean, amazing. So classes will start next week on Monday. Each day is a different type of family law matter. So Monday's divorce, Tuesday's custody, Wednesday is enforcement and modification, Thursday's trial skills. We will have the lectures recorded, so you can access those recordings at any time. And we really look forward to the kickoff. So join us this month if you're interested and take advantage of it.
Yeah, I'm just really excited for this. I'm excited to see what people can do when they have systematic, customized education for them. It's different than limited scope with a lawyer. It's different than hiring a doc preparer. It's really different. This is an interesting question. Can you explain what waiving a substantial change means and what the negatives and positives can be?
So I'm not exactly sure what they're asking about. I know if you're going to seek to modify legal decision-making or parenting time, you have to show a substantial change in circumstances. But I don't believe that requirement can ever be waived. It's,
right.
It's required under the law. The judge has to make findings regarding that and to order a modification. So maybe you're being asked to waive it. I'm not sure why, but I don't believe it can be waived.
For our last question, and then I want to answer any questions that people have about Win Without Law School. But our last question today is going to be looking for advice on how a parent can get sole medical decision-making when there's a disagreement between two parents.
So there's two avenues here. Either you're looking to establish custody and get sole decision making from the get-go, or maybe you currently have joint and you're considering modifying to try to get sole. So either way, obviously, you need to gather evidence and reasons why this is best for your child. Why do you need sole decision making? How does that affect your child or children? And how is that best? And really need to create a compelling case about why you having sole decision making in that area makes a difference. Because the court wants parents to share decision making, in particular for medical. I mean, there could be some really important decisions to be made about a child's medical care. And the judge doesn't want to block a parent out of that unless there's cause. And so what is that cause? And how are you going to convince the judge to do something the judge generally doesn't do?
Right. Joint medical decision-making is going to have to be harming your child currently, in my opinion, and in my experience, in order for you to get a modification giving somebody sole. So one parent has to be blocking treatment that is recommended and necessary for your child. And that's what you have to show. In my experience, you have to show that they're blocking your ability to get your child what they need, and that is not in your child's best interest. Because if you've managed to work around it, if they're just, let's say they're not involved and you have to do all of it yourself, if you're still able to get your child's needs met while having joint legal decision-making, I find that it's very, very difficult. Oh, the person followed up and said it's for the COVID vaccine.
Yeah, there's actually, I believe there was a case last fall where that was litigated in Pima County.
Oh, really?
I believe so. I'm not sure if there's been a ruling yet or where that stands.
And it went up to the Court of Appeals?
I just know that it was argued via oral argument at the trial level.
Got it.
Since then.
Yeah, there have been quite a few cases regarding this issue in Maricopa County, and judges don't want to touch it. They basically we in our office filed one at the beginning of last year in August, was I think when Delta was raging and it was really hurting kids. And one mom filed, her daughter had special medical conditions. She really wanted the COVID vaccine. That they ended up settling, but we've seen judges just not want to make that decision because it's a controversial one. It's a political one. So I don't know that. And what the other thing that's interesting is a judge is not going to want to take away somebody's medical decision making over this one issue.
Definitely.
Because that's a big deal, right?
Yeah, it is. So let's talk a little bit about, what evidence would you gather? I mean, not necessarily on this COVID issue, but just medical disputes in general to show it's harming your child. Doctor's opinion. That could be helpful. Documenting your child's suffering, or what is happening, getting the medical, just coming into court and saying he or she is making bad decisions is not as compelling as having a letter from the doctor or medical records or, a calendar of dates showing the ill effects on your child because of the parents, objection. That is much more of a strong case than just you coming in and emotionally expressing your feelings.
Generally speaking, when there are parents going through divorce and they have not vaccinated in the past, and now one parent wants to vaccinate, that also has come up, I would say at least, I don't know, maybe half a dozen times in my law office. And every time the judge went with vaccination, which is interesting because the non-vaccine parent argued, we decided this together in our marriage. Why does the other parent now get to go change their mind? But every single time the judge ended up going with basically the American Academy of Pediatrics recommendation. And I've seen them treat the COVID vaccine differently. So it's just, these are political issues.
Yeah, and I think it's going to continue to be complicated.
Yeah. And I would wonder if Yavapai County in Sedona, where people are a little bit more, I think, liberal and maybe less likely to vaccinate, if judges would treat it differently there.
It all depends on your judge. It all depends on your judge. But I haven't litigated that issue, so I heard about it, so I don't have any insight on that.
Well, we are out of time for today. I am super excited for live classes to start. To register or learn more, go over to winwithoutlawschool.com. If you register before the end of January, you get a 1-year access to live courses, recorded content for just $297. So that's super exciting.
Yeah, and join us next week. We'll be here again at 11 a.m.
Yep, we'll be here at 11. Thanks. Have a great day. Bye.
You too. Bye.